Okay, the case I will be discussing and analyzing today is a pending case involving a Massachusetts man who has been charged with negligent homicide earlier this month. Luke Garlinger, 29, of Mansfield, Massachusetts, was visiting some friends in Claremont, New Jersey, about 2.5 hours north of Mansfield. Garlinger had been out in the early morning hours of April 7th, and while he was heading home in his truck, driving eastbound on a busy Claremont street, he veered over the double yellow lines and struck an oncoming minivan head on. The minivan was carrying two passengers, Shelley Blaisdell, 42, and her 13-year-old son, Lakota. Shelley Blaisdell was transported to a nearby hospital where she died as a result of the injuries she sustained in the collision. Her son, Lakota, was treated for serious injuries, including two broken arms, and has since been sent home from the hospital to recover. Garlinger was also treated for some minor injuries. The collision was actually captured on the dashboard camera of State Trooper Brandon Dean. According to court documents, Dean began following Garlinger's truck after observing it operating erratically and at high speeds in downtown Claremont, just moments before the truck veered into oncoming traffic, killing Shelley Blaisdell, who did not have enough time to react. Also, according to the police affidavit, Garlinger's uncle told police that Garlinger had been drinking before the collision, and officers smelled alcohol on Garlinger's breath at the scene. Garlinger was arraigned on April 11th and is currently being held in Sullivan County Jail in New Hampshire on $50,000 bond, and he's awaiting trial. So that's the basic overview of the case, and I'll give my analysis and opinion on how I think the case should be decided. So to win a negligence case, the plaintiff must prove 5 elements. They are 1, duty of due care, 2, breach of that duty, 3, factual cause, 4, foreseeable harm, and 5, injury. The first element, duty of due care, states that if a defendant, in this case Garlinger, could have foreseen injury to a particular person, he has a duty to him or her. It is a proven and well-documented fact that consuming alcohol can severely impair one's ability to operate a vehicle. According to the U.S. National Highway Traffic Safety Administration, alcohol is a factor in 45% of all fatal vehicle accidents, while speeding is a factor in over 30% of those fatal accidents. Garlinger was both drinking and speeding, and the potential consequences from doing so were completely foreseeable. The second element, breaching that duty of due care, states that a defendant breaches his duty of due care by failing to behave the way a reasonable person would have behaved in similar circumstances. Tests done at the scene show that Garlinger was driving upwards to 80 miles an hour in a 35 mile an hour zone. A person does not reasonably operate a vehicle at those speeds, going twice the speed limit, especially after drinking. The third element, factual cause, states that if a defendant's breach led to the ultimate harm, then it is the factual cause. Garlinger's extremely hazardous driving was the direct cause of this collision. Had he been sober and driving the speed limit, it's likely that he wouldn't have swerved over the double yellow lines and struck the Shelley Blaisdell's minivan, and she would likely still be alive, and her son and family wouldn't be experiencing this physical and emotional damage that they currently are. Fourth, for Garlinger to be liable, the type of harm must have been reasonably foreseeable. Like I said earlier, with millions of people killed as a result of drunk driving in America every year, this type of harm was reasonably foreseeable to Garlinger. Lastly, the plaintiff must persuade the court that he or she has suffered a harm that is genuine and not speculative. The injuries sustained as a result of Garlinger's driving are obvious. One person was killed and another severely injured. So my verdict on this case, how I think it should be decided, with no contributory negligence by Shelley Blaisdell, I believe Garlinger was entirely negligent and should face the consequences. According to New Hampshire law, the charge of negligent homicide carries a 7-year maximum sentence. However, a charge of negligent homicide while operating a vehicle under the influence carries a 15-year maximum sentence. As of this time, Garlinger's blood alcohol content from that morning, April 7th, has not been released yet. However, I believe Garlinger driving at such excessive speeds of up to 80 miles an hour qualifies as ultra hazardous activity and will be enough by itself to charge him with negligent homicide, even if he was sober. If his blood alcohol content was indeed above the legal limit of 0.08%, I believe he should be charged with negligent homicide while operating under the influence. I think the Blasdales should be entitled to compensatory damages, that amount depending on how much income Shelley brought to the family. No articles that I found gave any facts on her employment status, so I'm not exactly sure. As far as punishment for Garlinger, I don't think that he should receive that maximum sentence of 7 or 15 years, depending on his BAC, because he's never been arrested for anything in his life. He has a completely clean record before this incident. I actually knew a kid growing up that was charged with this same crime in 2009, and he was sentenced to 5 years in prison, but was let out after 120 days in jail on good behavior. I think Garlinger should get a much stiffer sentence than that, but I think his past clean record, the fact that he was very remorseful at his arraignment, and the fact that he has a wife and 2 young children at home should also factor into his punishment. I think in some cases like these, rehabilitation may do more overall good than, locking him up for 15 years. I think his 2 kids growing up without a dad it doesn't do anybody any good. I think he should just maybe, serve some jail time. I definitely think he should serve jail time, but just maybe not as stiff a sentence, and then maybe enter some alcohol rehab classes, some driving courses when he's out of prison. I couldn't find the location of where Garlinger had been drinking that night, but it will be interesting to see if that venue is at all liable, if it overserved him while he was there. The case is heading to jury trial in Claremont Circuit Court in the coming months, and I'll be following it to see what the official verdict is. Thank you.